Well, I'm grateful. So we had left it at, as to the AT&T material, it may be unsatisfactory. It may leave the Court of Appeal a bit of a mess, but it should be clearer than this. If the material had gone in as we see it, and if there hadn't been an objection, and there appears not to have been an objection, then the material has gone in, and it's therefore to be dealt with, and it appears not to have been dealt with. And that would be a criticism of Mr Justice Calver for not dealing with it as late as it was. I mean, evidence does get admitted late into court proceedings, and if it's not procedurally excluded, then it tends to be considered as being in, and everything that we've seen considers that it had been included. And that's the first point. When one uses the word late, and there was a very short period anyway to get evidence in, and clearly it had just been discovered and that had been told to the court. Very often the court puts advocates under pressure and the parties behind them to come up with answers to material that's necessary there and then. And so the court can tolerate these sorts of short time spans, particularly in cases like this. That's the first point. The second point, as we've already heard, is that it was already happening and they should have disclosed it, and they knew it. And if they didn't disclose it, then they really can't take any complaints, make any complaints about not being prepared for it. They simply didn't know that the respondents were going to know about what they weren't disclosing.
So this is a proposition that a group of companies that's involved in getting a freezing order has to disclose worldwide litigation involving every member of the group. Is that right?
My lord, no, but standout circumstances, and these were standout circumstances. You're meant to be telling the court anything that's material that goes to the undertaking. The undertaking, cross-undertaking, deals with three things. One is worth, the second is liquidity, and the third thing is compliance, and that there's going to be no difficulty in enforcement of an order. Now, of the group that's got maybe other bits of litigation that they don't pay the debts of, this is a stand-up piece of litigation where, and the material in the unagreed bundle goes further, and as I think your lordships know, it goes to the fact that Mr Salinas himself made sure that he was authorised in order to be able to pass resolutions to move those assets out 3 days before. So he's orchestrating what's going on, and that's really significant.
We can see from the material you've shown us that the judgment in question was under appeal.
Yep.
Is there anything in the material that you've discovered which indicates whether there was an application for a stay of execution pending that appeal?
That's a very good question, my lord. I don't really...
We've seen from the material that you did show us
Yep.
that they said they were entitled to do what they did.
No, what happened is... Sorry, I beg your pardon.
Yeah, go on.
No, what happens is the material that is being shared now, it shows contempt proceedings are afoot. It shows that the receiver has been not able to get anywhere.
Just focus on the material you've shown us so far.
Yeah, of course. Okay.
For the time being.
No, of course. There's nothing in it that shows that there is an appeal afoot. Or that sorry, I beg your pardon.
It did.
I beg your pardon.
It said it was under appeal.
I'm sorry. I meant to say that there's nothing to show that there was any application for a stay that I have seen. And I'll ask that to be checked behind me.
I mean, you can fairly say that the judge proceeding on the basis that it was an immediately enforceable judgment, but if there'd been an application to an appeal court for a stay, that might put a different complexion on things.
I don't want to make unattractive point after unattractive point. The material is there to push further. My second submission has been that there should have been disclosure of this material. If there is any contemplation of regrant or continuation, that material becomes in play, and then you could look at the new material. It's new material, but it's their events. They know exactly what's happening. I've already shown you material which shows that there had been agreement as to what had been going on. There's been agreement as to evasiveness. There's been agreement as to the cessation of representation by Paul Weiss, and the basis of that being a disagreement. So a lot of what I've shown you has been agreed. So the new material, as it were.
Sorry,
where we left it off before the short adjournment was, I think I showed you the agreement to release Paul Weiss from representation in America. of the two Salinas companies.
Yeah, it's the 8th of August.
Yeah, the 8th of August. Yes. Yep, my lord. So that's before the court. So all I'm saying is that it's not in dispute. This material doesn't appear to be in dispute. These orders have happened, and the procedural facts are the procedural facts. If I were permitted to, I would show you further procedural facts. Well, but it is not that contemplated by Calver.
It may not be controverted that all Weiser have come off the record. That doesn't mean that there is agreement that the purpose of that was in order to defeat the judgment.
Well, I think it does.
I don't want to slow you down because I know you have...
No.
But the suggestion that these are matters which are agreed, as it were, struck me as something you hadn't yet shown me.
Well, I think it's because it's in later material. I think it's as simple as that. We'll clarify that. Okay. Well, I don't think I'll press it. I won't press that issue. Can I just show you two things quite quickly, which are bits of evidence? I did advert to them earlier. I think it would be convenient for you just to see if you found in the supplemental bundle tab 20, and if you were to find page 151. This is at paragraph 76. There's other material here under severe financial difficulties from paragraph 72 onwards. But 76 is that list that I told your lordships and my lady about this morning. That's A to M. And a lot of that relates to TV Azteca as part of the group or the conglomerate. For example, A relates to TV Azteca and specific allegations against Mr. Salinas for profiting from regulatory frauds. And that was concluded with a no admission but no denial deal for $7.5 million payable by Mr. Salinas and $1 million payable by others, and effectively almost like an old-fashioned carecraft order, a 5-year disqualification period from being a director.
Which had come to an end well before which we are concerned.
I'm just pointing it out to you, Lordship. But that's the sort of thing that might have been. Your Lordship will recall that there was the case that we saw this morning, which is that a past tense non-disclosure of somebody's mere arrest and charge, let alone what happened to them thereafter, was viewed to be material disclosure. And this type of thing, which is quite serious, we would say, is something which is anyway admitted. What I wanted to point out this morning was, if you look at this list and page 159, which is the answer to it, so tab 21, the next tab, page 159, paragraph 45, goes through the list. And you can see that, I think I've fairly summarised it, that depending on whichever list you're looking at, might be easier on 76 as well, that A is admitted, B is admitted, C is admitted, D is admitted, E is admitted, events of it are admitted, i.e. that there's this tax row. What's said about that at page 159, little 5, is Grupo Electra and companies associated with Mr. Salinas are involved in a dispute with the Mexican Tax Administration Service, which commenced in February 2023. The dispute is ongoing. And then there's denials in respect of F, G, and H. G is the bondholders' dispute, which I'll show you. G, as to G, what's said at little 7 at 159 is the bankruptcy court in the Southern District of New York dismissed the bondholders' petition in November 2023, which is something like half the story. It's not talking about whether the underlying debt is there. And what the best evidence that I think we've got is if you turn to tab 31, so a few tabs further.
Tab 31.
31, my lord, 31. This is a piece of journalism in respect of the bondholders' action. The headline being, Mexican magnates firm says it's too poor to pay US bondholders the tens of millions owed. And then, if you, under the photograph, picking up the second paragraph, well, the first paragraph is failed to reach agreement with bondholders who are owed tens of millions of dollars in past due payments. Second paragraph, Salinas' TV Azteca company issued a statement Tuesday saying it needed a restructuring of bonds because business was so bad. 2 paragraphs later, according to the statements, the dispute involves about $400 million in bonds with about $105 million in past due payments. And it's an unusual situation for Mr. Salinas, who frequently takes to his social media accounts to hand out money or merchandise and post photos showing his lavish lifestyle, etc. Over the page, he also often posts strings of stinging insults. Second paragraph, according to the company's statement, the bondholders want $105 million repaid when a deal was reached in exchange for a restructuring that would grant a 6-year extension to 2030 on full repayment. TV Azteca had offered a $45 million initial payment and a mix of 6- and 8-year extensions on the bond's due dates. The company said it had been hit by the coronavirus pandemic, a decline in advertising, the continued deterioration of the TV broadcasting industry and Mexico's economy, as well as additional pressures on the company's cash flow generating capabilities, i.e. all the pressures of any type of business in an economy. None of that can be seen in Mr. Salinas' social media posts, where he posted last week that to take advantage of the long weekend, we went to New York City to see what to buy at the art auctions. He also posted videos of a yacht and private plane, writing how pretty the fruits of my labour are. So it's something to do, the sort of thing that one would be concerned.
Since you've taken us to that evidence, what's your submission about what Mr. Sklarov himself says in his fourth witness statement at tab 22, paragraph 26, where he himself says that Mr. Salinas owns a 105-metre super yacht, the Lady Mora, of which he's still the owner for a sum similar to that lent by Astor 3. So round about $115 million worth on Mr. Sklarov's own evidence.
Yeah, well, what is your lordship's question?
The question is, why is that not ample to meet any liability on the cross undertaking?
But because, my lord, super yachts, the fact of having a super yacht, or if that is the case, it was
never a very realisable asset, is it not?
It might be
sold straight away.
Well, is that known to your lordship? I mean, super yachts go fast from being super yachts to yachts when actually somebody is trying to sell them, and there's no evidence of that whatsoever.
Excuse me, there's evidence from your client that Mr. Salinas owns that super yacht.
He did, because he thinks that it might have been perhaps a nexus between the loans and that, notwithstanding that it was said to be refinancing. He's raising it, but there's no dispute that Mr. Salinas tries to live a lavish lifestyle.
So I don't understand it. What is your submission? That it's worthless? And on what basis?
I don't know. It's to do with disclosure. There's nothing disclosed about his value. Your lordship goes.
It's said to have been bought for 125 million.
Yeah,
that's your client's evidence as to its value.
Well, that's just the value of the price it's said to have been bought at. But that doesn't mean that that's disclosure that was at an ex parte stage. This is after the event. This is part of what am I worth, assets and liabilities. You know, it's just on a grand scale. And he's got grand scale liabilities and possibly grand scale assets, but we wouldn't know because absolutely none of it is disclosed. That's the point.
So let me see if I've understood this. The submission is that the freezing order should be discharged because he failed to disclose his ownership of a super yacht worth $115 million odd, which your client now accepts that he does own.
Well, my lord, it wasn't said as in such a slanted manner. I've said there's no disclosure whatsoever of his worth, and there's no disclosure of his liquidity, and there's no disclosure of his ability to comply with an order. And everything screams that he won't comply with orders, doesn't comply with orders, and he doesn't give any evidence whatsoever to disclose. So it can't blame a respondent who's given no information about somebody's single line assertion where they leave themselves completely exposed to all sorts of findings that might go against them. And then when provoked into evidence, doesn't respond at all in an obstinate way, refuses to say anything about their wealth, apart from a blandishment that might be wrong. And the fact of having acquired an asset doesn't mean that that asset has the value that is said to be, that the value is retained, that the value is his. I mean, this was bought through a corporate vehicle.
No, it's said in your evidence, it's in his own name.
Okay, well...
Please, be
no, of course, I'm trying to be careful, my lord. I'm simply saying that is one line from Mr Sklarov, and that is not a disclosure of the fact that there is net asset value. That's all I'm saying to you, Lordship. And yes, it might be a big asset, but the man deals in big assets and big liabilities. We can see that for ourselves. So this goes back to what was said at the time, what disclosure was made, 0, and when pressed, 0. And everything that's been quoted back at me is something that our own client introduced. In any event, the point of showing the article was to deal with the bondholders' complaint, which makes it look like there's unsatisfied debt, and the bondholders are trying to press, and what is being said back is that they either are forced to cram down and participate in an agreed restructuring, which never seems to come, or in any way are being stymied from actually being paid. And that's the sort of thing that we submit respectfully. It is the sort of disclosure that the court should know about, and goes to the third point, which is the fact that there will be enforcement compliance. That's the point. When I said to my Lord Justice Popplewell this morning that there was other evidence, that's the evidence I wanted to show. Thank you. Can we identify further to our skeleton argument where we say that the learned judge fell into error? And if we start with paragraph 117, we in paragraph 117, the judge starts by saying the same point can be made in response to Mr. Bayard's submissions concerning Mr. Salinas' wealth. Now, the same point refers to what is quoted in paragraph 114. Sorry, I'll let your lordships catch up.
Yep.
Thank you. In 114, there's an extract from Briggs, Matt and Elcombe, which is taken out, and there's the reference to, in the middle of it, the borderline between material facts and non-material facts. So that point may be a somewhat uncertain one. And then Mr. Salinas' wealth, 117, the same point can be made in response to the submission concerning Mr. Salinas' wealth. This is his beginning of his analysis of these submissions. And in our submission, that's wrong. It is the point made in the immediately previous section, there's a margin of error between material and non-material facts, as I pointed out. But as we hopefully showed you this morning on the authorities, the ability to meet the cross-undertaking is always material. It should always be anticipated by an applicant seeking an injunction. It should always be dealt with by an applicant in the level of the detail that we contend for. So it isn't a question of being a borderline fact. That's not the territory we're in. That's just simply wrong. That is then leads on to the discussion about whether there's been any evidence about whether he's ready, willing and able to repay all the sums owing to Astor 3. That's in 119, because there were two submissions that were being made in respect of the need for the disclosure. One was the disclosure relating to the cross-undertaking. The other one was a disclosure about him being ready, willing and able to repay all the sums owing to Astor 3 immediately. And that's why it was also notable that there was no disclosure of any ability to actually meet that specific sum, such as to see through and complete the causes of action that they were complaining about, and the ability to seek rescission of the SLA, and therefore put the lender back into the position whereby they could be repaid the loan to undo the agreement. And there was no evidence as to that, and you've had my submissions in respect to that. Paragraph 121 responds to 120, which is the suggestion that Mr. Salinas, by Mr. Bayard, is not a wealthy individual. He's got massive financial woes. He's been beset by scandal and is guilty of tax evasion. And that is dismissed as being all highly contentious. And we submit that that's the wrong approach. That the judge was not being asked to determine those questions, whether Mr. Salinas, for example, was guilty of tax evasion. What he was required to determine was whether the claimant's failure to provide any evidence of Mr. Salinas' financial standing, in the way that I've defined it, was a breach of full and frank disclosure. So the point is not that the judge could reach a concluded view about any of these scandals, but that the claimants ought to have properly put them before the court. Just as Mr. Justice Scott, as he was, decided that the Mr. Block's arrest and charge should have been put before the court. And that was all that was necessary to dismiss and not renew the injunction. The authorities relating to not determining contentious points and the trial within a trial are not dealing with a cross-undertaking. They're instead recognising that the claimant, the applicant, only needs to show a serious issue to be tried at the interim stage in relation to contested factual or legal matters. But the ability to provide the cross-undertaking is completely different to that. And for the reasons that we've seen this morning, is what is required as a condition to make the application. The inquiry was wrong. The point was that the claimant had knowledge of these issues and should have raised them. So that is as equally relevant to paragraph 122. There was a factual point procedurally that was taken and then dropped by Mr. Bayar, which was that in fact these issues of impecuniosity and inability to pay the tax authorities and the regulators and those matters were raised 3 times in 2022 and twice in 2023. Ultimately, that point was abandoned by the Astor defendants at the discharge hearing. But that's not the end of the matter. The applicant had knowledge of the issues and should have disclosed the issues, is our position. And that was true regardless of whether or not the future respondents were actually provoking the matter by asking the letters. They should have been disclosed voluntarily. Paragraph 123 then deals with fortification from 123 to 125. And the judge appears at this stage to have considered that the lack of application for fortification meant that there should be no concern over Mr. Salinas' ability to meet the cross-undertaking. And that could really be the only reason why that's being raised. And in the skeleton argument that was put before that judge, Mr. Justice Calver, on the relevant day, that's at the supplemental bundle tab 10, which I'll ask your Lordship to just look up. I wanted your Lordship to look at this for a number of different reasons, but I've tried to summarise it accurately. It's 52 pages long, deals with a very large number of facts and legal positions with very large drop-in sections on various areas of the law, but it deals specifically with fortification. I'm just trying to get the exact reference. Apologies, my Lord. There's one particular paragraph where fortification is raised, and this is what Mr. Justice Calver responds to. So he's led, I'm afraid, down the path of dealing with fortification rather than dealing with it as a necessary form of disclosure. I can't find it, but maybe somebody can find it behind me. So the point is that fortification, and this is an important point of legal principle here, it is, for the reasons I said this morning, it's conceptually different, separate and distinct from whether or not the cross-undertaking is satisfied. Fortification arises when the court has concerns that the applicant may not be good for the cross-undertaking or enforcement against the cross-undertaking may be difficult. Hence, the Commercial Court Guide makes provision for that. And I will just ask you to turn this up briefly. So that's at tab 31 of the authorities bundle. Sorry, not 31. 32. Page 777. And fortification of undertakings at 14.3a, where the applicant for an interim remedy is not able to show sufficient assets within the jurisdiction of the court to provide substance to any undertakings given, it may be required to provide security. The giving of security or fortification means that the claimant must effectively put its money where its mouth is. But that is premised on the claimant giving fair presentation on its ability to meet the cross-undertaking in the first place. If that does not happen, the court will not be informed, so will not be in a proper position to consider fortification. And that's wrong, and that is why Lord Justice Mayles, in granting permission, highlighted that fact. And that, I'm sure your Lordship's got it ready to hand, is in the core bundle, tab 8 at 144. And in that, Lord Justice Mayles says, it's arguable that the extent of Mr Salinas' wealth was not fairly presented to the judge. While the allegations may be contentious and the judge could not be expected to resolve them, it's at least arguable that they ought to have been disclosed as a matter of fair presentation on the without notice application, regardless of any subsequent application for fortification. At the time of the return date, as it happens, the respondents were not ready to make an application for fortification. But I should tell you, Lordships, have just made an application for fortification. We didn't put the material before you in the bundle, but I should tell you that an application for fortification has been made. Not pure and simple. It's been made together with an application to reduce the value of the order that's live per Calver J, and to discharge it on the basis that the value of the residual is now 0, but that in any event, that one of the options that the court has is fortification as an alternative. So I should inform your Lordship of that. Thank you. Yeah. Maybe I'll just tell you, Lordship, that the whole idea about fortification was introduced in the skeleton at, I'm told, the supplemental bundle 14 at 123. Yeah, thank you. At para 134. And this is all that's said about Mr Salinas' wealth from paragraph 130 to 134.
This is for the set-aside.
This is for the discharge.
Discharge, yeah, for the discharge.
What you're showing us is essentially what was adopted by the Justice Calver.
Exactly, my Lord.
And your point is?
Well, my point is that it's fair to show your Lordships that that is the case. And how did fortification come to be? Fortification came to be, it appears, because at this point, the judge should have resisted it.
Mr Justice Calver's judgment, it was raised by Mr Baer as part of his submission. I mean, it's true, I mean, as you've shown us, I mean, it had come up in this skeleton as well.
Okay, thank you. Well, I don't need to press the issue. The point is that we criticise the judge as being incorrect in pursuing that for the reasons that I just identified. Paragraph 123, we also say that it's wrong to say that the collateral was $415 million, and that isn't accurate. The share price collapsed dramatically, such that the company collapsed in the stated value in the market to 186 pesos a share.
Mr. Davenport,
My
you've
lord.
had more than 30 minutes
Yeah.
now, and Mr. Clougherty must have some time to...
Of course. Could I just spend just 2 or 3 minutes of what you should do next? And I just refer your lordships to the case of Valbon Estates, probably well known to this court. It's at tab 27. It refers to the relevant authorities on the number of factors that should be approached. In particular, I would highlight in paragraph 62 that in dismissing the challenge to the judge's discretion, the court stated that the general rule is that the order should discharge and the court should refuse to re-grant it. So what I suggest is the only fair thing here. There's been a dramatic breach for the reasons I have stated. It's been obstinately held on to. The court should discharge the injunction. The issue of re-grant on terms or otherwise should simply not arise. The Court of Appeal is just as well placed as the Commercial Court to do something about this, and they've had their opportunity to remedy the position in any way, evidentially, and that time has come and gone, and they've done that quite deliberately and electively. So they can't now provide further evidence to deal with issues that they've chosen not to deal with deliberately or since. So that ship has sailed. And in those circumstances, then what the court should do is to simply remove both the freezing order and the proprietary order. And there's no difference in terms of how the court should approach it. The proprietary injunction, the non-disclosure, goes to the cross-undertaking in respect to the proprietary injunction. It doesn't matter that there's a different test or route to getting to proprietary injunction. That's got nothing to do with it. What's relevant is that there has been a failure at the incipient stage, which is the cross-undertaking stage, and therefore both orders go. In those circumstances, those are my submissions. I apologise for taking longer than my allotted time.
Thank you. Mr. Clark.
May it please the court. By way of high-level overview of our position, our primary position is that not only were all of these allegations, not findings, allegations, highly contentious, but they don't provide any support at all for the defendant's contentions when you look at the material. So there was, we say, clearly no material non-disclosure. And in any case, when you look at the material, the claimants couldn't fairly be criticised for not bringing that contentious material to the court's attention at the ex parte stage. Contrary to the way that it's put in the defendant's skeleton, this is not a case where there have been multiple findings of dishonesty about my client. There have been no findings at all. What the defendant's case really boils down to on this appeal is to say that the claimants should have trawled through every controversy that every company, every underlying trading business in the conglomerate had ever been involved in what was necessarily a fairly urgent application. That's what it really comes down to. And in my submission, that suggestion is both contrary to principle and disproportionate. If it's right, in a case like this, there could be no end to the material that the claimant would have to disclose. So we say there's no material non-disclosure. Now, My learned friend today advanced a new case, or at least what I would suggest is a new case, which is that the lack of detail, as he would put it, in the initial disclosure of wealth in Salcedo 1, it's those paragraphs 6, 7, 8 that my Lord Justice Popplewell first drew attention to. His new case is that that was not enough. It was insufficient. And that an insufficiency of disclosure amounts to grounds for completely discharging the order that's made. As to that new case, we make a number of points. One, that case was not advanced below. You don't see it in the judgment. We were just looking at the small section of the judgment where the judge
Mr.
deals.
Davenport accepted that. He accepted that it wasn't advanced below.
Thank you. In any case, that sufficiency point, we say, is not challenged on the appeal either, but it makes no sense. So that's our primary position, no material non-disclosure. Our secondary alternative position is, even if the court were against me on that and were to find that there was some non-disclosure, plainly the injunction should not be discharged. But as the judge found, there is a strongly arguable case that my clients were defrauded. There is plainly a risk of dissipation. As the judge also found, the injunction has in fact managed to preserve a substantial amount of the proceeds of the fraud, or the proceeds of sale of the shares. It wasn't deliberate, we hadn't anticipated the attacks that came, and it would obviously be unjust simply to discharge the injunction.
And it's your case that if we get to that stage, that's a matter that should be remitted to the judge because he's better placed,
Absolutely.
being aware of all the other evidence in the case.
And as my learned friend mentioned to the court just at the end of his submissions, less than 2 weeks ago, the defendants extremely belatedly issued an application for fortification. We say it's a pretty transparent device to do it so many months after the event. It's a transparent device just so they can say that there is an application for fortification here. But actually, if you got to that stage of the analysis, I say you shouldn't, but if you did, then there will be, at some point before the commercial court judge, a debate about fortification in any event. My Lord, in terms of what I'm going to say, I propose to address you under 5 headings. Firstly, some background, really to explain or to address why the defendants say this alleged non-disclosure was material. What does this non-disclosure go to? What's the target? Secondly, I will mention extremely briefly the correct approach to this appeal and the question that arises. I suspect we won't need, in fact, to address that. It's in our skeleton. Thirdly, I want to say something about the relevant principles, especially with reference to disclosure in respect of meeting the cost undertaking. And then, fourthly, I want to look at the disclosure that was made and look at all of these attacks, these articles and what have you. As the court may have picked up, so turning to my first head, background, and what does this all go to?
So did you say you've got 5 headings?
Sorry.
So you've got 5 headings. I've only noted 4.
I'm so sorry. The fifth heading, which I've already anticipated, you're quite right, my lord. The fifth heading is the remedy. So if the court's against me, what should it do? But I've summarised that, I think. In terms of background, my lords, my lady,
do we need any more than is in the judgment and in the skeleton argument?
Well, my lord, I just wanted to draw attention to one point, which was sort of adverted to by my learned friend towards the end of his submissions. I'm sure you've all picked it up. All of those shares were sold long before we actually obtained the injunction. There is no dispute about that. So when my learned friend was quibbling with what Mr Justice Calver says in paragraph 125 of the judgment, I was slightly bemused. And the reason I'm highlighting this background is to show why my learned friend's point about the alleged inability to repay this non-recourse loan and the ability to make counter-restitution is material. He basically said there are two reasons it's material. One is the cross-undertaking, and the second is the substantive case itself, repaying the 115 million. The second of those is an extremely bad point, because it is admitted that immediately after the shares were transferred by way of collateral to the claimants, the defendants set about selling those shares in small amounts on every trading day from the moment they got them until April 2024, turning our 7 million odd shares into $415 million. So when
does this go to the first point, the main point, as to whether there was material non-disclosure? Surely that question has to be addressed by reference to the position at the date of the without notice application, by reference to the relief that was being sought and the basis on which the relief was being sought. And at that stage, the relief included a proprietary freezing order over the shares and any proceeds of the shares. And one of the reasons that was put forward as giving rise to an entitlement to those sums as a proprietary remedy is that there had been a valid rescission for fraud, and therefore the equity of redemption was being exercised to regain proprietary title to the shares. Now and it was in support of that case that on two occasions in the skeleton it was said on behalf of the claimants that they're ready, willing and able to repay the loan, albeit they weren't going to do so if they didn't get the shares back. But that was the basis of the claim to an entitlement, or at least one of the bases of the claim to an entitlement to a proprietary remedy. Now, does it matter to that it's now known that the shares have been sold?
It does, my lord. I quite accept, just to be clear, that the real target of my submissions is going to be the cross-undertaking and damages. So that's one of the 2 points that's made, and I will address that. So far as your lordship's particular question is concerned, we have to remember that what we're dealing with here is an appeal against the decision of Mr Justice Calver. And one of the points that Mr Justice Calver makes is that all the shares were sold. And so it's perfectly legitimate for me to say that you couldn't possibly, Mr Justice Calver couldn't possibly, and certainly this court couldn't possibly, discharge an injunction for material non-disclosure where it transpires that the non-disclosure wasn't material. And I think we see that.
Sorry, I just don't follow that, because the basis on which the proprietary freezing order was sought posited that the shares might have been sold. and it claimed either the shares if they remained, or the proceeds of sale of the shares if they had been sold, on the basis at 113 of the skeleton that was rescission and exercise of the equity of redemption, which involved having to say ready, willing, and able to repay the loan. That's the position at the ex parte stage. Why is the fact that Mr. Calver knew, or that we know, that the shares have been sold affect the materiality of the assertion that Mr. Salinas was ready, willing, and able to repay the loan?
I take my lord's point. I suppose what it goes to is whether, in those circumstances, you would ever discharge.
Well, I could see it might go to the second,
and on any view,
the alternative basis.
On any view, yes. And so I say, even if there was any merit in the point, obviously I say there isn't any merit in the point, and I'm going to come on to explain why in a moment. But it would never be discharged on that basis. The real gravamen of the attack is in relation to the cross-undertaking in damages. Can I...
You had another point, I think, which was these were non-recourse loans, but I think the same arguments either way apply to that point, don't they?
Well, I mean, that was obviously always the case, so there was never any question.
Well, it may always be the case, but if the proprietary relief was sought on the basis that you were ready, willing, and able to repay, then the fact they were non-recourse loans is neither here nor there.
No, I see the point. Can I... So that's the background. It is important to understand that background for the in terms of the contention that the court should discharge the injunction. Can I turn then to look at the target? This is my second heading. What is it targeting? It's targeting the ability to repay. We've just discussed that, and the cross-undertaking in damages. The court, however, is really looking at, as it were, at the exposed period from the date of the ex parte. So what the judge on the ex parte is really thinking about is this person good for the money, knowing that I'm making an order where the defendants will be coming along on the return date and can take whatever steps they wish to. And that's, in my submission, what Mr. G is getting at in that passage we looked at earlier in tab 29 of the authorities bundle at...
Yes, just on that, can I be clear? The period we're talking about is from the 2nd of August to the 29th, because the 29th was the return date specified in the first order.
Yes.
Correct?
Yes.
Yeah.
Although I've forgotten what I did, it wasn't an effective return date, because that actually took place in...
Which is why they
in mid-September.
pitch up in mid-September.
And that's probably a more realistic date to take.
I quite accept.
For exposure, given it was the vacation.
Yes. I quite accept that. So it's really the period between the Mr Justice Jacobs decision on the 2nd of August and the Mr Justice Calver hearing on the 20th of September.
Thank you.
And it's at page 757 of tab 29. It's about halfway down. It starts, the duty continues after the ex parte application, includes a duty to return to court. Then he says, until proceedings have reached the stage where the defendant is in a position to make his own applications to discharge or vary the injunction. That's the exposed period. And with respect, my learned friend's submission that fortification...
I'm sorry, I missed where you were. Could you give me that reference again?
My lord, it's tab 29,
Yep.
757, about halfway down.
I was on the wrong page, thank you.
And that's what that Appellants decision says, is it? Was that more just concerned with the continuing obligation?
I think that Appellants is continuing obligation, but...
It may not identify the end point.
But
I understand the logic of your position.
The basic point, my lord, is that there is an exposed period that the judge is looking at on the ex parte. And when you're deciding whether what was said was sufficient or fair or material disclosure was made, whichever formulation you want to use, that's what you're looking at. And my friend's submission that the question of fortification and discharge by the defendant is completely separate and distinct from the cross-undertaking and damages is completely unrealistic. The judge can't fairly be criticised for saying there comes a point where it's down to the defendant to decide if it's going to apply for fortification, and this defendant hasn't applied for fortification. Perfectly legitimate for him, as he does in the judgment, to take that into...
But surely at the without notice stage, the judge has to consider whether a defendant will be adequately protected for the exposure period against the risk of loss caused by the freezing order being in place during that period.
Of course.
And it's to that potential loss that the question of the adequacy of the cross-undertaking applies. It's no answer to that to say, well, as it happens, when it came to the return date, there wasn't an application for fortification. If there wasn't adequate disclosure to enable him to decide whether there should have been at the without notice stage. Is it?
No, I agree with that, but we're looking at that exposed period.
So it's not an answer to say they haven't in fact made an application for fortification, is it?
No, but it's relevant when they come along and say that the injunction should be discharged for material non-disclosure, because what impact has it had if there's no requirement to fortify? But I quite accept what we're really concerned with here is, was what Mr Salcedo said sufficient? And I'll tell the court straight away, my submission is, it was.
Well, I understand that. But one of the questions that hasn't quite been squarely addressed yet on either side is if the question is whether there were adequate means to make the cross-undertaking worthwhile. What does adequate mean in the context we've just been talking about? I.e., if this is the right test, the best estimate or guesstimate, intelligent guesstimate, that the judge can make on the 2nd of August, looking forward, as to what loss might be caused over the exposure period, given that the freezing order is going to enjoin the use of shares, which will have a fluctuating value, and our assets, which, if the defendant is constrained, might give rise to a loss under the cross-undertaking. How much do you say that is?
Well, it's very difficult. It's not an enormous sum, because it's in the exposure period. It's really trying to work out what the loss might be. But the point that was being made in Salcedo 1 is that here you've got an extremely wealthy person whose worth is...
Yeah, I know, but before we drill into the evidence about how much it is, I know you say the evidence shows he's got billions. Mr Davenport says he's hardly got anything available. But the question, the first question is, to what amount of value of assets was disclosure about assets material? I haven't expressed that very well, but if it's on the cross undertaking, it is what is on a proper guesstimate might be lost over the exposure period. Then you might say that's a few 100,000. You might say it's a few million. You might say it's 100 million. You might simply say that if, on the alternative basis, the ready, willing and able to repay the loan of 110 or 115 is an alternative standard that has to be met, well, it's going to be less than that, so that's the figure that we ought to be worrying about.
Well, can I answer the question in this way then?
Yeah.
It could never be more than 115 million in our case.
Why not?
When you're looking at that, when you're the judge on the 2nd of August, you're looking at what's the... I quite accept my Lord's conceptual way of putting it. The judge is saying, in this exposure period, what could the loss be? Or the judge is saying, what is the amount that the defendants will claim is owing? We know the second is 115 million. As to the first, it's really difficult to put a number on it. But if it's millions, if it's tens of millions, if it's hundreds of millions, we're good for the money, is what we were saying to the court and what the court was accepting.
So, would you accept that what we're looking at is whether you're good for, Mr Salinas was good for hundreds of millions? Or would you say, can't realistically be more than 115 million, and since that's the figure we're looking at?
It can't realistically be more. My learned friend hasn't identified,
No, he hasn't.
and this is the problem, and it does shade into fortification in relation to that first of my Lord's 2 points. The second is easy because that is quantified, 150 million. The first, never quantified. And as the judge puts it, I think in paragraph 125 of the judgment, not only have the defendants never said what the number should be, yes, they have now. Less than 2 weeks ago, they made an application. But at the time, in front of Mr Justice Calver, they never said, and the point that Mr Justice Calver's making is they've never said what the number should be. And in any case, as his lordship said, it's really difficult to see now what that loss could be. Because effectively the defendants, when they gave their asset disclosure, didn't have anything other than what they'd received from us.
It's nothing to do with what we know now. It is on the 2nd of August, Mr Justice Jacobs is sitting there thinking, what I'm being asked to do is grant an order over these particular shares in these particular circumstances for these particular defendants. It's without notice. I have to do the best I can to make a realistic estimate of the sort of sums which might have to be called on the cross undertaking to cover the exposure period.
So as I understand it, your submission is that the worst case scenario is that the order causes a complete loss to the defendants of the sum in dispute, which is 115 million. You say that's the worst case scenario. We've heard your submission. There was never any case from the defendants as to anything other than the worst case scenario. And for the reasons you say, we now know that the worst case scenario won't have expired. My Lord has put to you, well, one didn't know that the 2nd of August.
No.
So, but then the question is, well, what should Mr Justice Jacobs have had in his mind? So, one submission is, or one possibility is, has the worst case scenario in his mind. But it might be thought what he should have also had in his mind, something short of the worst case scenario as a possibility of loss to the defendants, which might need to be covered by the cross undertaking.
Yes, and so...
And what kind of ballpark figure would you say that he should have had in his mind for that?
I'll tell you the conceptual way of calculating it, and then I'll try and do the maths in my head at the same time. But the way that judges often approach this, and the way that I would answer that question, is to say, look at the sum that's frozen, and then, and in practice, judges often do a sort of rough and ready feeling. How much interest would you have to pay in order to borrow that sum in that period, the exposed period as I've called it? So, on any view, the judge...
That's fine just for a regular freezing order. But here, the shares were frozen. And I think it was your client's case, at the time, that they were worth much more than the amount of the loan. So, my lord's worst case scenario is not just 110 million. A complete collapse in the share price would have left them with shares they'd been prevented from selling, which at the time were, your client said, worth, I think, 400 and something million.
Yes. And
would be worthless. There might be all sorts of questions about whether you could recover all that on a cross undertaking, but I'm not sure it's entirely right to say that the maximum could have been the amount of the loan conceptually. One might very well be able to say, well, realistically, given the timescales involved, trading shares, although suspended at the time, and so on.
Yes, but conceptually fine. It's in which case it's 415 million, or that on my lord's reasoning. Yes, I mean, I'm not trying to be difficult. I mean, it is a really artificial exercise when we found out almost immediately that they had all been cashed in long before, and the 415 million had been turned into money. But yes, my lord is right. Conceptually, that is the maximum. I mean, whether I wouldn't accept that even at the ex parte stage, most judges would regard that as the realistic upper limit, because what judges do on the ex parte is the best they can, and inevitably there's not a lot to go on. But I don't think, we'll put it this way, I'd be very surprised in the commercial court if a judge said to me in this situation that you had to pay, that your undertaking was covering the full value of the shares, because that obviously posits going from 415 million to zero. But conceptually, that's a way of thinking about it. But even if it's 400 million, our position is, well, we are extremely wealthy and in a position to pay, because what was effectively being explained in front of Mr Justice Jacobs was that the first claimant, Mr Salinas, had 30.4% of the group, which is listed. And so we had about 67 million shares in the group. He was alleging that 7 million had been stolen by the defendants. That left 60 million, which is the point that Mr Salceda is making in, I think, paragraph 8 of his witness statement. And therefore, we know, because it's listed, that quoted price then of, I think, 1,050 or subsequently 944 times 60 million shares is about 3.5 billion. So absolutely straightforward, adequate disclosure. And whether Mr Justice Jacobs was thinking in terms of 115 million or 400 million, evidence was put before him. My friend kept saying there was no evidence. A sworn witness statement is evidence.
Well, on that point, can you just help us as to exactly what happened? Because commendably, the parties have been selective with the documentation, and that's entirely in accordance with this court's practice. But nevertheless, it's sometimes helpful just to have a fuller understanding. So the document we have is what is entitled on its face. This is tab 17, Mr. Salcedo's first affidavit. And the last page we have is what was originally page 143 in the bundle. And as I pointed out before, on its face that's a little odd because we've got these two paragraphs with did not use, and we don't even have a jurat page, let alone knowledge of what actually happened subsequently. Could you just help us with that?
Yes.
He does explain in one of his later.
If we go to,
affidavits.
yes, it's page, tab 21, page 153. He explains that paragraph 2, I previously made 3 affidavits in these proceedings. It was originally signed as a witness statement on the 1st of August.
Right.
And it was subsequently affirmed on the 5th of August. So the one we have, as I understand it, someone behind me will pull up the last page of tab. What should be the
How does that square with the fact that Mr. Justice Jacobs' order recites that the applicants relied upon the first affidavit of, this is page 15 in the Bible. Surely if it had been,
Should say witness statement.
if it had been a witness statement, that would have said witness statement.
It probably should have said witness statement.
Oh, you think that's just a mistake?
Well,
I mean,
the
the skeleton
skeleton argument says affidavit as well.
No, the skeleton argument says, in fact, the skeleton argument says there will be a signed witness statement. It's obviously been prepared before it's actually been signed. There will be a signed witness statement, and it will be affirmed in this
Yes,
content
and it was.
in due course.
Yes.
Sorry
my
to
note was-
interrupt,
isn't that
my
what
friend.
skeleton
The
says?
suggested reading list, I'm just saying, page 62, says, please read the first affidavit of Mr. Salcedo.
Paragraph 224 sheds some light. This is page 112 in the bundle. Mr. Salcedo signed a near final version of the affidavit in the early hours of the morning UK time. Some minor changes were then made by the applicant's legal team overnight without affecting the factual substance. In those cases, the final version affidavit included in the bundle is unsigned. Mr. Salcedo is asleep. An anticipation, a signed version of the affidavit will be provided shortly before or during the hearing and will be followed up by a sworn version.
And yes, and there is no dispute that the sworn version was produced shortly after. What I'll get to the court is the full before Master Meacher took the bundles in hand. These bundles had complete versions of all the documents, and the master rightly said, "Go away and decide whether you need everything." And so we took out a lot, including I think the
Right. Okay.
Jurat
Well,
page.
I'm
Yes,
sorry
my solicitor
for
is-
taking up time on that, but I think it's a little clearer now.
Yes, thank you. No dispute that it's signed. That's what he says. And we say that what he says, or rather what he said, in the affidavit that was before Mr. Justice Jacobs, was enough.
Yeah, so your first submission is that there was evidence before Mr. Justice Jacobs, and any question of the sufficiency of that evidence, you say, is not open to the appellants for the reasons you gave earlier. And that then takes us on to the question of non-disclosure.
Exactly. Can I jump to that? I was going to say something about the authorities, which I'll come back to if I have the time, but I think I'll just instead jump straight to the question of alleged non-disclosure. The various matters that the defendants rely on have shifted. As my own friend was at pains to point out, before the judge below, they advanced some 13 points under this ground alone. As the court would have picked up from the judgment, there were 6 grounds of alleged non-disclosure before Mr Justice Calver. The first 3 were substantive, if I can put it that way, about the underlying case. There was then a question of delay, was the 4th. The 5th was an allegation about our improper motive for seeking the order, and the 6th was the wealth report. There was a 7th about the notice of default. I'll come on to that in a minute. That was basically abandoned, although my own friend's skeleton tries to resurrect it. But within that 6th heading in relation to the wealth, there were some 13 points. My learned friend took the court to Mr Sklarov's witness statement, paragraph 76 earlier, which has a whole series of trivial and scattergun points. But if I can put it this way, the overriding theme was to identify Mr Salinas personally with every single company in underlying trading company in the conglomerate of which he is an owner. And I say, as a matter of principle, that's wrong. What you need to do is look at the actual claimant, Mr. Salinas, and focus on whether there's anything about the actual claimant that was withheld.
Well, can you push it that narrowly? Because in this case, the evidence that was relied on before Mr. Justice Jacobs was primarily a general statement about Mr. Salinas' wealth, and specific evidence he has an interest in electro, and that interest is worth more than 3 billion, to take a round number. So surely it would be material for there to be, if anything was withheld with regard to that specific company, and more specifically, his interest in that company.
I accept my Lord's point, which is if there was something material known to you about the value of your interest in the company, yes. But that's not, if we just stand back and think about the matters, and they've changed over time. There were 13 before the judge. There were different ones focused on in the skeleton in support of the application for permission to appeal. And then my own friend's skeleton for this hearing alights on 6. But what they are is assertions about the behaviour of those companies. The way that Mr. Bayard effectively put it, and the way the judge encapsulates it in the judgment, is that these are all allegations about those companies which tend to show that Mr. Salinas was guilty of tax evasion, dishonesty, and all the rest of it. The judge summarises Mr. Bayard's submission beset by scandal, guilty of tax evasion. That's what they're really all about, these complaints. And so when you look at the particular complaints in this case, they don't in principle apply. Because what it really amounts to is that some of the underlying trading companies are in dispute with the tax authorities about the correct amount of tax that needs to be paid in respect of historic audits, for example. How can that possibly be something that Mr. Salinas personally, as a personal claimant, needs to bring to Mr. Justice Jacobs' attention? If a person in his position, so with an ownership interest in an enormous conglomerate, has to tell the judge at the ex parte about every single controversy that the underlying companies are involved in, whether it's a tax dispute, a controversy with bondholders, whatever it is, there would be no end to these applications. How could you possibly do it in the time available? It is, with respect, completely unrealistic. The other important background to the alleged material non-disclosure is that, as Mr. Justice Calver held, the defendants were forced to abandon their contention that they had put the claimants on notice of their contentions about Mr. Salinas's financial position. In paragraph 122 of the judgment, the judge talks about 3 letters that the defendants had relied upon to demonstrate that all of these issues had been raised with the claimants long before the ex parte. Now, the obvious purpose of them deploying that point was to say, aha, we put you on notice that we were going to make all these attacks on your probity, and therefore you should have brought those attacks to the attention of Mr. Justice Jacobs. In fact, when we pointed out we'd never received them and asked for the metadata, as the judge points out, those letters were promptly abandoned by the defendants, and in the final sentence, Mr. Justice Calver points out, Mr. Sklarov's solicitors confirmed that they no longer rely on the letters. So, another thing you need to remember when you're coming at all of these, now I think 6 attacks on things that should have been disclosed but weren't, is there is no suggestion, or in my submission, no credible suggestion, that the claimants should have appreciated that the defendants would make the attacks on Mr. Salinas' financial probity that they, in fact, made.
In the skeleton, although not, I think, in Mr. Davenport's submissions, it was suggested that a number of these were matters that were adverted to in the notices of default.
Yes.
Which relied on financial impairment as an event of default. And then we looked at those. But that's different from the 3 letters you're talking about.
That is different.
The judgment. Yeah.
I was going to come to the notice of default, but if I can just address it now while we're on it. The question of fair presentation about the notice of default was previously the 7th ground that Mr. Sklarov and the other defendants relied on. If we look in his first witness statement, please. That's at tab 20 of the... Oh, I'm so sorry. It's not here. It's not here because it's not actually relevant, because it wasn't persisted in. but basically, one of the points that Mr Sklarov raised was fair presentation in relation to the notice of default. And paragraph 7 of his first witness statement, perhaps we'll provide you with the whole of that as well afterwards, if that would assist. It's not in because it's not relevant, which kind of makes my point.
Have you got the notices of default themselves in it?
No. But what he said was, a further respect in which Mr Salinas failed to present the respondent's position concerns events of default under the SLA. What we do have, what I can show you, is, ironically, we addressed this in our skeleton before Mr Justice Calver, because we thought that one of their challenges was going to be this notice of default. So if we go to the supplementary bundle, please, at tab 14.
Is the notice of default at tab 51 in the supplementary bundle?
I'm so sorry, my lady is quite right.
I thought I'd seen it somewhere. Because whilst
Yes.
I saw reference to it in the skeleton argument, I thought, oh, where's that? Let's find that.
Thank you, my lady. But on page 123 of tab 14, you can see our skeleton below. So we addressed it below. As point 7. As the judge records, only 6 points were advanced before him. So Mr Salinas' wealth is number 6. And Mr Bayard didn't run that 7th ground. So although we'd addressed it, and the answer to it, most of the answer your lordships and your ladyship can see on paragraph 136, is that, well, we did present the notice of default, obviously, to Mr Justice Jacobs, because one of our points was that the notices of default we feared were an instrument of the fraud, because they were seeking to justify their ability to sell the shares. So, I mean, it was a bad point anyway, but for today's purposes, it's not very fair or reasonable for my learned friend to resurrect the notice of default.
I don't think it's... I can't quite tell because we haven't got the full material, but I don't think it's the same notice of default point. What you've just been showing us seems to be a suggestion that they haven't drawn attention to the fact that there had been a notice of default which was being relied upon as having accelerated the loan. The point that, as I understand it, is relied on in Mr Davenport's written skeleton, although he didn't develop it for us, is this wasn't a question of you having to trawl through a lot of material in order to work out what the other side might have wanted to say about impairment of Mr Salinas' financial position, because not very long earlier a number of these were specifically relied on in the notice of default itself. I don't know if that's right or wrong, I haven't looked at the notice of default, but that I think was the way it was relied on in the written argument.
And my lord can see in paragraph 135, it was put that way. Point 7 below was that what we hadn't done.
Yeah, but that's not quite the point, because if we look at the notice of default, supplementary bundle, tab 51, page 442, there's an item there, material event non-payment of taxes. And so it's no good simply telling the court on the 2nd of August there's been a notice of default. And we say that doesn't help the defendants. On the contrary, we rely upon this as part of our case. Without also, so the argument would go, drawing to the court's attention, one of the things that's being said in the notice of default is Mr Salinas isn't paying his taxes, putting it crudely.
Yeah, but it doesn't say that. It says that there's and this goes back to my point about it not having been, in any event, a material non-disclosure about the claimants, remember it's Mr Salinas who's the claimant, ability to meet the cross-undertaking. It might be relevant when we come to, and all of this is pleaded, by the way, in the proceedings. It might be relevant on the substance, but in my submission it was never relevant, or there was never a requirement for us to say that we anticipate that because they've made this point in the notice of default, that on the return date they will come along and say that Mr Salinas is impecunious because one of the companies in the conglomerate is in a dispute with the tax authorities about the payment of taxes. That would never have been material, in my submission, to Mr Salinas's willingness and ability to pay the judgment sum.
Well, it might if it related solely to the value of Electra. I mean, if it were the case that Electra did in fact owe the tax authorities 63 billion pesos, then that would have a material bearing, wouldn't it, on Mr Salinas's, on the value of Mr Salinas's shareholding in Electra.
Yes, if it were.
I know you
Sorry,
said it, I know you
it
said
would
it is,
fit with the case. The point is that the Electra annual revenues are more than 3.8 billion. So I accept my Lord's point. If
we're looking at the value of his shareholding, there are various different ways of valuing shareholdings. It can be price earnings, discounted cash flow, whatever. But if we just look at earnings, one's got to look at profits, either before or after tax, not just income. If you're valuing the company, and what the accounts show is there was a small loss for the second quarter for the Electra Group, but actually a profit of about 60 million for the first 6 months. So that's what you get on income, and you get some figures for the consolidated balance sheets, for the balance sheets both on a consolidated and non-consolidated basis. I understand all that, but if it be the case that what was said about there being a tax liability would substantially change that picture, that might be material. No?
no,
Because it might affect the value of his shareholding in Electra.
well, no, because all of this, by definition, was publicly available information. So all of it, Electra's listed. Electra's one of the listed ones.
Yep.
So all of this information would have been in the public domain and reflected in the share price anyway,
Yep.
with respect. So that point, I see my Lord's point as a matter of concept, but in fact, no, because it would have been reflected in the share price. And which is to say nothing of all the other assets as well, including the assets that Mr Sklarov complains about us having, like the yacht. So no, I don't accept that. So I don't accept that anything in the notice of default was itself material for the purposes of Mr Salinas's ability to meet the cross undertaking. And it wasn't, this point wasn't advanced below. If I can just summarise it in that way, Mr Bayard did not push this point below, despite the fact that Mr Sklarov had alleged in his witness statement that there wasn't a fair presentation of the defendant's concerns, is how he puts it, in his witness statement, that are reflected in the notice of default. So it's a bit unfair, we say, to criticise the judge in relation to a matter that wasn't really advanced before him. So that's a very long way of if I can just come back to where we were, which is the important context is in those circumstances, and this is the point the judge is making in the judgment, it wasn't in the event suggested to the judge that we should have appreciated and that we should have brought to that it was a material non-disclosure because we should have appreciated. And that's why, that's why they fabricated the 2022 and 2023 letters in the first place, one assumes. Because what they were trying to show, but then accepted they couldn't, was that we should have been, we should have had some inkling that this would be the basis upon which they would attack the cross undertaking. This is a world away from the cases that you were pressed with this morning, Block and Nicholson. Block and Nicholson was a case where Mr. and Mrs. Block were personally the plaintiffs. And it transpired that a couple of weeks before the ex parte, Mr. Block, who was the plaintiff, had been charged and remained charged with fraud. Nothing like that in this case. It's not like Manor Electronics, which was, I think, one of the other ones that was pressed upon the court this morning. In that case, the two companies that were the plaintiffs knew, because their own financial statements showed, that they were in fact in a very parlous financial situation. I have also just alluded to, but I'll flesh the point out. Most of these points that are the judge describes as highly contentious and that we're discussing today are also issues in the action. I suspect the court might have picked that up, but they're all pleaded in the defence in one way or another, and they're all addressed in our reply. And so when the judge says, I think by reference to the Kazakhstan, Kagazi and Arab case, that generally the court is just not going to get engaged in determining matters which are an issue in the proceedings. Well, these are.
Well, that can't be a general principle, can it? If the fact of the allegations is material. And if the underlying basis for the rule is, as Lord Justice, the passage quoted by Lord Justice Slade suggests, and I think I picked up in Fundo Sombrero, that dealing with things without notice is prima facie a breach of Article 6, and it's only not so if, in the limited circumstances in which one can do it, one can rely on the other side to make a fair presentation and to draw to the attention of the court those matters which the other side, it can be anticipated, would wish the court to consider.
Yes.
And that can include matters of this nature, which may well be contentious and which the court needs to be aware of, even if it's going to decide that it can't decide who's right about it. And there may well be a distinction between, on the one hand, allegations which are just further allegations by one of the parties, in which the court really can't decide whether they have any worth at all as allegations, and charges by a third party, such as what is said by a judge in proceedings or prosecution on a criminal charge, or what the tax authority says. But do you say that the mere fact that these are going to be contentious matters that are going to be the subject matter of resolution in the action, ex hypothesi means they can't have been matters that ought to have been brought to the court's attention?
I can't, I think,
I think that's a bold submission.
I don't think I can go that far.
No.
But what I can say is that the matters that the defendants now rely on are highly contentious and irrelevant, and we did not need to disclose them to Mr Justice Jacobs on the 2nd of August, which is all I need to say. By way of background, as I say, often people try and say you should have anticipated that the defendant would have made this attack. And that's why I spent a bit of time explaining one of the judge's points about the defendants giving up their reliance on the idea that we should have anticipated all of this. So once that goes, the question is, should we have? Without knowing that that's what the defendants would say. And I say, when you look at them...
You can't generalise in that way, because it's always case specific. So if, for example, you had known something about the value of Electra, which, as at the 2nd of August, was not in the public domain, and therefore you knew about it, but there's no way any defendant could know about it, but it became public, let's say a week later, and was highly damaging to the value of the company, surely you would accept that you were under an obligation to disclose it to the court.
Yes, but these 6 are just not in that category.
Yeah, but that's the point, isn't it? That's the real point.
Yes, and all you really need to do is look at them and decide, should the allegation that is made in this press article, because they are allegations, they're not findings.
Well, the one difference, of course, is when we come on to the New York judgments, which we'll obviously need to consider separately.
Yes.
They stand in a bit of a different position.
But even then, the finding is that GST, Grupo Salinas Telecom, the company, has been engaged in activity. But I will address the New York in a moment. But that's the question. You look at them, should we have drawn them to the court's attention? I say, obviously not. The first of them is the so-called tax debts, which we saw. And really what it amounts to is press allegations about the tax authorities pursuing...
Yeah, well, and the same articles relied on, as I pointed out to Mr Davenport, say how extremely wealthy Mr Salinas is over and above the alleged tax liabilities. So that doesn't really help.
I'm grateful, my lord, and in that regard, my lord did anticipate one of the points that I was going to make about that article. The next one is the bondholders allegation. That wasn't really relied on in before the judge below. And what my learned friend says in his skeleton is that this article shows that Mr Salinas publicly stated, and I underline Mr Salinas publicly stated, that TV Azteca is too poor to pay bondholders. And if we look at the article in tab 31, It just doesn't say that. It's the article, when you look at the actual article, is talking about the company's position. So, second paragraph, the company issued a statement. Next paragraph, TV Azteca said, over the page, according to the company statement, the company said. And it said particular things, fine. Now, of course, the press are going to put a picture of my client on the story in the same way that if there was a story about Tesla, you'd probably get a picture of Mr. Musk, or if there was a story about Microsoft, you might get a picture of Mr. Gates. But the idea that he is responsible for every... Because that's what it really comes down to. My own friend Skeleton misstates the position, because this does not say that Mr. Salinas has said anything. The bit at the top is the headline. It's the journalist's headline. So the too poor to pay bondholders doesn't even come from the company. It's the journalist's headline summary of what the article says. But even then, the headline says the firm is saying it. So, should this article have been drawn to the court's attention? No. The proceedings that are referred to, as is explained in paragraph 45 sub 7 of Salsada 4, the petition had been dismissed in November 2023. But the fact that one of the trading companies below is having a fight is not something that we had to draw to the court's attention. And in any case, this article just doesn't say what paragraph 23 of my learned friend's skeleton alleges it says.
And TV Azteca is a separate company from those that are within Grupo Electra, is that right?
Yes. I think it was my lord earlier who I think was referencing one of those Grupo Electra documents which explains a bit about the...
Yeah, 253.
Yes.
Page 41, 253. There's a bit about company profile.
Exactly, yes. Exactly.
Suggests that Grupo Electra
is one part of the...
is the commercial, retailing and financial services, including the bank. And then there are various others in the group.
And just while I'm on 253, my lord, note also that each of the Grupo Salinas companies operates independently with its own management, board of directors and shareholders. And I obviously rely on that. I mean, it's absurd, the idea that my client is responsible for every day-to-day management decision in every single one of these companies.
TV Azteca is again a publicly listed company, isn't it?
I believe so.
I think the evidence suggested.
But the bondholders' petition had been dismissed in November 2023. But so what? The article just doesn't say what my learned friend says it says. The third point is the New York material. And as we all know, the judge didn't rely on this, and he didn't rely on it because the material that's in the supplementary bundle on this, which my learned friend kept referring to, I'm glad that my lord clarified this point. My learned friend kept saying these were before the judge and in evidence. They weren't in evidence before the judge. They were handed to him.
They were before him in the sense that they were sent by email late the evening before.
Yes, and we know from the transcript that he in fact got them. His clerk handed them to him
That morning.
What there was not, and we've addressed this in paragraphs 121 to 132 of our skeleton. But the critical point, my friend kept saying, well, there was no application to exclude this evidence. Well, there wasn't, because it wasn't evidence and there was nothing to exclude.
Well, was there an objection to Mr. Bayal seeking to rely on it?
I don't think there was a direct objection in the transcript.
Was there an indirect objection?
There is a discussion towards the end. And just remember, this is point 6 of 6 by the time we get to wealth. So it's all dealt with really quite quickly at the end of the transcript. And there's some reference to, do you need me to deal with Annex A, which was all about reducing I believe was all about reducing the amount of the injunction, and the judge says no. But there's no direct objection. I accept that. But what I do say is that my friend has it completely the wrong way round. The judge was perfectly entitled to ignore this material because there was no application before him, as there would have needed to be, to adduce it into evidence. So the judge was perfectly entitled to ignore it. And in any event...
By which you mean exhibiting it to a witness statement, yeah?
Yes. Well, and then adjourning the hearing, obviously, to allow us sufficient time to...
Was there an application that Mr. Robbins didn't directly object to it? Did he suggest that he needed an adjournment to have time to deal with it?
I don't think he suggested that in terms. No, I can't say that. But if there had been an application to produce this into evidence, then we would have, obviously, needed time to address it, more than just... I'm
not understanding what you mean by an application to introduce into evidence. Sometimes one has a timetable set out, that evidence is to be served by a date responsive evidence.
There was a timetable.
And there was a timetable, so that you're saying that there needed to be a variation of the timetable.
Yeah, and that's why Mr. Davenport accepted that this material came in late, because it was not in accordance with the timetable.
Yeah.
But his point was, although it was accepted to be late, it wasn't objected to. That's his point.
Well,
where do we see the judge's or somebody else's timetable?
Someone will.
There's an order somewhere.
Someone will get the order for me. But we do have to be a little bit realistic. It was incumbent upon the defendants, if they wanted to put in this material, given that there was a timetable.
If there was an order that the evidence must be served by X and Y, and then this was produced at the last minute, I quite understand your submission that they needed an express
someone behind me
extension
will
or
provide
variation of the terms of that order. If on the other hand, as not infrequently happens, material is produced at the last minute and one party relies on it and the other party doesn't object, then generally speaking it's treated as being accepted in evidence.
Well, I think the most that could be said is that the judge ignored it and we did. Because it's right to say that the judge doesn't deal with it in the judgment.
Well, that's not an answer to the point that he should have done.
And the answer to the should he have done, my answer is no. The judge would have been perfectly entitled. If he'd said in the judgment there were these allegations made about the New York proceedings, which I got on the morning of the hearing, and I'm just not dealing with them, he would have been perfectly entitled to do so. That's exactly what happened in similar situation in some of the cases we've got in our authorities bundle. In the PIFS case, in tab 26, Mr Justice Jacobs, I think Justice in that case, said that he was just not going to deal with the lately advanced case, and that was that. That's tab 26, authorities, page 691. And then at 695.
So you were referring to Annex A, but I've been looking at the transcript, and that seems to be Annex A to the skeleton argument below. What was that about?
And so that, it plainly can't be about the new material.
No.
Because it's in the skeleton.
Correct.
It's about, from memory, their alternative application to reduce the amount of the freezing order, because they said that we were the limit was too high. So it's not to do with that. There's no direct objection.
It's all very odd, because so far as I can see from the transcript, from the brief perusal that I've had of it, for the limited evidence extracts we have, Mr. Robbins didn't object to this material coming in, but he didn't address it either. He just ignored it.
Yeah.
Is that right?
I think, I obviously wasn't there, but that was the conclusion I had reached as well. But in my submission, he was perfectly entitled to ignore it in the absence of any application. I'm told it's not in the bundle, but there was an order of Mr. Justice Brian Yeah, 29th of August 2024. We will send this to you.
I think we have got his orders actually, because I think they're attached to
Oh, are they attached?
Mr Justice Calver's orders. Maybe it's only the injunction part.
I think it's only the substantive orders, my lord.
Right.
But in any case, there is an order of Mr Justice Brian that said that the evidence had to be in by 16th of September. It's pretty general.
Perhaps you could provide that. The other thing, the material was served with an email on the previous evening. Was there an objection advanced in correspondence by solicitors?
I have asked somebody to look at that. My own friend says no. I've asked someone to double check that, because it's the question I had myself this morning, was why didn't the solicitors? But even if they didn't, and being fair to everybody, considering this was point 6 at the end of a long, difficult process, we were entitled to ignore it in the absence of an application, i.e. an application.
Take your chance as to whether the judge ignored it.
Yeah. Well, the judge did ignore it,
Well,
and he was entitled to as well.
On that, can you help me on this? I noticed that the time estimate for the hearing was 2 hours, which seems remarkably short. How long did it actually take?
My learned junior thinks it was a day.
Right.
He's probably the only one in court who's actually there.
Actually, I'm sorry.
It's definitely a day, because there's a lunch and a journal.
I'm sorry. It was the time estimate was 1 day. I was looking at the wrong document. I apologise.
But there was an awful lot to get through. So
even in a day, there was a lot to get through.
yeah, and so hindsight's a wonderful thing. I wasn't there, but I can see from the sheer volume of points that were taken, there was a huge amount to get through, in defence both of Mr Robbins and in defence of the judge. And this was a tail end Charlie point 6 on the wealth. And you can see from the transcript that it was dealt with really quite quickly. I think you've got the entirety of the transcript in relation to the wealth point. and it's really a few pages. So in my submission, it's impossible to see how this point can be relied on in this appeal. And it's no
I'm
answer.
sorry to spend some time on this. Just going back to the document that Mr. Bayar in fact relied on, which I'm in tab 16, looking at the transcript at page 131. At line 13 on page 70.
Yes,
Invite your
well,
Lordship to find the one on the 8th of August.
that's the one I think at tab 44 of the supplementary bundle.
Yes.
Now, the point about that is an even more straightforward point.
But just humour me for a moment. Was that the only one of the documents that Mr. Bayar went to?
Yes,
I think it is.
I think it is.
Right. So in terms of the material that was put before,
Yes. Well, to be even fairer to the judge, it was only the one that's the most irrelevant.
it's actually one document. It's not the suite that we've been shown by Mr. Davenport.
Yes, although I do
that
think
right?
it's yes, I do think it's right to say.
It's quite important that we.
I think it's right
down
to
what the
say
position is.
that the ones at 36, tab 36 of the bundle,
Yes.
our bundle, and tab 39 of our bundle,
Yes.
were attached to the email.
Yes.
But the one in tab 44 is the only one
The
that
only
Mr.
one
Bayar went to.
which was relied on before the judge at the hearing. Exactly. Tab 44.
Was the one that the decision that came after, 6 days after the application to Mr. Justice Calver.
Yes, I mean, obviously, the one at tab 44 is utterly irrelevant because it postdates.
Well, it predates the without notice applications in relation to D5 and D6, doesn't it? Or have I got that wrong?
I think one of them, I think D5,
One was
maybe
on the
7th
7th.
of August, and I think one was after, one before and one after, my lord. I think is correct. 7th and, yes, 7th and 13th, I believe. So either side.
But it's fair to say that the real focus in front of Mr. Justice Calver was the big one on the 2nd of August.
Yes.
And as I say, if the judge had simply said in the judgment, I'm not dealing with this 8th of August document, full stop, there could be no possible appeal against it.
That may make it a little more comprehensible as to why Mr. Robbins didn't think he needed to
It may do,
object
actually, in fairness to Mr. Robbins.
or deal with it.
So that's the AT&T document. There are a few more. I noticed the time. There are really 3 more in the skeleton, in my learned friend's skeleton. I think I have dealt with the 3 that he described this morning as his best material, which is the New York judgments, bondholders action, and the
submissions
tax.
on the others.
Yes. And so if you would please, to the extent you feel it necessary, you've got my, rather Mr. Robbins' skeleton in relation to those.
Yeah.
I notice the time. In summary, none of those items was material in the sense of being something that should have been drawn to Mr. Justice Jacobs' attention. And as I've said, if my own friend's right, and that kind of material should have been before the judge, by which I mean, allegations in newspapers about this, that, or the other, then in a case like ours, there just would have been no end to the material. And clearly a sense of proportion needs to be engaged. I think in Kazakh Kagazi, Lord Justice Longmore talks about there being degrees of relevance. And he says, we can turn it up if it's useful, tab 19 of the authorities. He says, basically, there are degrees of relevance. It's important to preserve a due sense of proportion. Sensible limits have to be drawn, he says, because otherwise there would be no limit.
I suppose as a practical point, before you ever get to deciding whether or not you should disclose material, there's a potentially enormous amount of research which solicitors who are preparing these applications would have to do in the first place in order to identify material that potentially should be disclosed.
Yes, and one of the points that Lord Justice Longmore makes in Kazakh Kagazi and Arab is because of the circular nature of the test being something's material if it's material to the decision that the judge was making on the ex parte. In theory, there could be an enormous compass. And he says you've got to be a bit realistic, and you've got to be, he says, realistic in a case where there is urgency, which there was in this case. My own friend tried earlier to make some suggestion that we've been at the prep for weeks and weeks and weeks. That's
6 weeks, he suggests.
yes. I'm not waiving privilege in any way, but my learned junior was rather upset about that. Because sorry,
make it clear in the script. Sorry, carry on, please.
That's just not fair. In any case, the court will recall that the judge deals with an allegation about delay on our part in the judgment, and he rejects it. When he rejects the question of delay, he also says, well, even if there had been culpable delay, I nonetheless would not have discharged, but rather I would have maintained the judgment. This is paragraph 107. Because clearly justice requires it, because there's plainly a risk of dissipation, and there's obviously a good arguable case. And so, under my 6th heading, which I should probably get to given time, what should you do if you're against me? I say, well, it's quite obvious what the judge would have done if it got to this stage of the analysis, because when he was considering a related question, he said, well, I would have just continued the injunction anyway. And really the points that are made in Kazakh Kagazi, my lady, about the due sense of proportion and seeing the wood for the trees and not being unrealistic, all come out of Brinksmat and Elkin, where effectively that the court was making the same point. We saw reference to it earlier about the borderline, as it's put, between things that are material and not material being quite difficult to draw. And Brinksmat also draws attention to the tendency of litigants to cast around for alleged non-disclosure because they think that represents their best chance of getting read of an injunction that they can't otherwise.
Yes, there is some authority in this court. I think it was Lord Justice Mayles deprecating that kind of behaviour, a scattergun approach to.
It's actually Mr Justice Mayles in a
Mr.
case called Eurov, which we have in our bundle.
You needn't take it down. That's where it is.
It's in Eurov.
Well, I'm less familiar. Could you just go very quickly to the.
My lord, yes, I think it's tab 19 of.
Yeah.
Oh no, sorry, that's Kazakh Ghazi. We have. I do apologise. 21. And Eurov's actually quite a helpful case, and if we could perhaps pick it up at page 511. His Lordship makes the point that it's essential to have a succinct summary of the grounds relied on so that you can have a properly focused application. And then over the page at 15, and this I infer is why my learned friend's appeal skeleton picks out 6 points of non-disclosure, because Mr Justice Mayles, in that case, as in this case, there was a morass of points, and Mr Justice Mayles forced the defendants to choose their 6 best. Because, as he said, if you can't make your case by reference to your 6 best points, then you're unlikely to do better by piling them on. And then over on page 514 is where we see the scattergun. And as he says, the claimant must disclose material facts, but that need not extend to a detailed analysis of every possible point which may arise, and the defendant must identify with clarity, and if necessary restraint, the failures of which it complains. And then in paragraph 20, his Lordship quotes the bit of, if the court needs a reference to the relevant part of Kazakhstan Kagazi that I was talking about earlier. An important point that's made in that quotation from Kazakhstan Kagazi is not just, secondly, there are degrees of relevance, but of course the point that the more complex the case, the more fertile the ground for raising arguments about non-disclosure, and the more important it is not to lose sight of the wood from the trees, otherwise there'd be no limit. And then at 22, his Lordship makes the point about, well, sometimes once the whole action is over, with hindsight you can see hotly contested issues of fact can only fairly and finally be resolved at the trial. Throwing paper at an application to discharge does not render disputed issues any easier to determine at an interlocutory stage.
Thank you.
And as I say, what's really happened here is that on the return date, the defendants hunted around on the internet to find some mud to sling, and effectively then reverse engineered the suggestion that there was material non-disclosure by not drawing that material to the court's attention. It's perfectly fine for defendants to do the hunting around on the internet looking for mud. But what it doesn't amount to is saying that you should have disclosed those things to the judge at the ex parte. When you look at the stuff that's relied on in this case, there just was no material non-disclosure. My sixth heading was going to be remedy, but I think
you covered that twice already, actually.
Yes. So unless the court has any questions.
No. Thank you very much.
Thank you.
So, Mr. Talbot, any brief submissions?
Fine. Can I restrict myself to about 5 minutes? The sum involved, as it were, the price, that I agree with Lord Justice Popplewell that I didn't actually sort of put a price tag on. I think I dealt with conceptually the idea that you don't know whether it's between 0 and a large amount of money. But if you are Mr. Justice Jacobs at the time, you're trying to fix on the figure, doing the best that you can. I just wanted to give you some targets, as it were. I think there is, you've got to approach it on an inclusive basis. You've got an absent party, you're going to protect the absent party. You're also going to be on the inclusive and generous side, not the restrictive and ascetic side. You're not going to go for the, how much could he have put it in Barclays premium account rate. You're going to have a look at the world that they live in. So you have to put it into that context. It's not money that's spent and lost. It's going to be fortified, so it's not ever being lost. So there is a temptation to say it's a like-for-like approach. That would be the natural thing to do, because by source of the goose and the gander, it's not only the respondent who is going to put the issue before the court on the discharge date, but it can equally be the applicant who could do so and say, well, that was a very generous approach by the judge on the ex parte hearing, but we've challenged the respondent now to actually try and make good on what possible need there would have been for this sum of money, and they haven't, or they have, and we challenge what there is. So none of that process was followed. So if one is asking for sort of what would you do then, I think you're inclusive, you're generous. Like for like has a symmetry to it, which is natural. It's not being lost money.
Well, that's not my experience of the practice in the Rolls building. I don't know whether it's yours.
No, well,
fortification is not automatically taken by default as the amount of the freezing.
No. I accept that in the general case, and I didn't say in the general case. I just said in a case like this is the unusual circumstances whereby this money is one party is going to say, and is covered off in a very extensive submissions. Do look, please, if you can, have the time, at the 52-page skeleton argument, even by chapter heading. You see how much time is devoted to the full and frank when it comes to what arguments might be had on the SLA. And so the parties are using the money in free flow. So I'm simply saying one of the ways of just protecting about it is if you say it's $415 million worth, then there would be a symmetry to actually putting $415 million of fortification, at least for that short period. Secondly, you should know that the fortification sum that's sought is $696 million. Of course, that's not before the court. And the figure that was said to be the amount to discharge on the payment back of the loan was $113.9 million at the time, so just shy of $115 million. It was, I think, because of various shifts of currencies, $113.9 million, so actually less. So those on figures.
I'm so sorry, Stan.
I'm so sorry, Melanie.
I expect I'm missing something because this just isn't my field. But as I understand the transaction, $150 million were lent, and collateral was given for that loan. And the value of the collateral seems to have been much greater than the value of the loan. So what I'm not understanding at the moment is how the defendants could lose more than the value of the loan.
Well,
I expect I'm being really stupid, so please explain.
Not at all, but first of all, the concept of the defendants, they're not all in one pot. So one thing that we need to get straight is that Astor 3, which is the first defendant, it didn't sell the shares. Why are you laughing? Well, didn't sell it, it pleaded,
basic
and it's not pleaded in reply.
Well, is the short answer this, that it was the defendant's case
Yeah.
that they had validly terminated the loan agreement and that the effect of that was that the shares were forfeit and they were entitled to keep them all. So if they turned out to be right in their defence, that was their case, was it?
That's only part of their case. Their case
wait,
was...
wait a moment.
Sorry.
If that case were made out at trial, and it was determined that they had been entitled to all the shares, irrespective of the value of the loan, then those are circumstances in which they could say, what we have lost by not being able to deal with these shares, which should have been our own, was up to the value of the shares.
Well, my lord, I think it goes much further than that. It's just that Astor 3 rehypothecated them to Vanderbilt, and Vanderbilt sold the shares, and the claimants brought action against everybody without distinguishing, and has lumped them all in together. And so the judge has to protect all of the defendants in those positions. So I'm simply saying to you, the range of options of the figures would include the fact that Astor 3 has rehypothecated to Vanderbilt, and Vanderbilt has gone and sold. And Astor 3 has been shut out of the market in various ways, which it does describe in the material you haven't seen for the purposes of its...
Sorry, maybe I'm missing something.
Sorry.
Vanderbilt was not a respondent to the freezing order.
Yes, it was.
It was eventually. It's one of the ones later.
No, originally. It comes in later.
Yes. But it's part of the same package of three.
So Vanderbilt comes in on the 7th.
I think it's the... Yeah, it's the 7th. Yeah. It's the D5. Yeah.
Because we got the asset disclosure. I mean, I didn't go long on the background because I didn't anticipate this would be the reply. Right. But if these sorts of points can be made, then I would like to say something about the background to the case and the judge's finding that all of these companies...
Let's cut to the chase, because we still have not had the answer to the question, which is how on earth, even on a worst-case scenario, you could lose more than the value of the shares.
Because you're missing out on the trade and the shares are plummeting in value. And
I'm presupposing that you're right, you forfeit, the shares are forfeit to the claimants, so they're your shares. And I'm also presupposing that somehow the effect of the freezing order is entirely to destroy the value of all those shares. So they go from whatever they're worth to zero. So you have a total loss of the value of the shares. But how can you claim more than that?
My lord, I don't think now is the time that I can express this. What we have set out a counterclaim for what is about $360 million,
which is less than the alleged value of the shares.
$351 million plus another claim. This is responded to at page 324 in the reply when the following is said. Okay. 324, tab 15. RBS and Mr. Salinas have more than sufficient resources to meet the DWF defendants' contested counterclaims in these proceedings, which are currently quantified in the sum of around $351 million plus interest. That actually leaves aside one of the claims, which is for another figure to be worked out by reference to expert evidence. So that's acknowledged. That's available to be seen in the defence, which sets it out at full length as to how the counterclaim, which is actually not that long, is said to be, and it follows from being deprived of the loan and also damages for breach of the SLA agreement in the first place, which is $252 million, and that's fully pleaded, paragraphs 177 onwards at page 254. So that is the answer to the question, and I, in my short time, invite your lordships and my lady to have a look at that particular passage. I wanted just to say that please look again at tab 16, not now, of the transcript where Mr. Bayard is addressing the AT&T issue, the New York proceedings. And all that I want you to take from this is that Mr. Bayard makes all the points that could be made from the suite of documents that I showed you. And he makes all those reference, even though to one of the documents, which does post-date the Mr. Justice Jacobs order, because that document basically catches up on what has happened, which is reflected in the two previous documents that I showed you. That's a fair submission, And if you look at that document, you'll see it for yourself, which shows about the judgment, shows about the evasion, shows about the movement of the monies 3 days later, and the orchestration by the parties. And it comes to the conclusion that, and it recognises that Paul Weiss is exiting as legal counsel. So, and he made very specific submissions which are in line with exactly what we say in the skeleton argument at tab 16, page 132, internal page 72 and page 73, in particular internal page 73. He basically says that's the sort of thing you've got to bring to the court's attention. And that's all that I'm saying to my lady and your two lordships. And the only other thing that I wanted just to cover is that if tax debt of $5 billion is not something that needs highlighting and is just a mundane piece of business in a huge enterprise which doesn't come to the attention of its group chairman and leader, I should be very surprised. And that clearly isn't how any of the press are reporting it. It's a long campaign between the government at its very head, including the president of the country, over 10 years, involving numerous cases, and they don't draw any of this to the court's attention. That's your lordships and my lady's conclusion, so be it, but I suggest that that is something which should raise the eyebrows. And my last point is that it certainly should have raised the eyebrows of Mr Justice Calver, that what was going on in AT&T must have been of some relevance and certainly deserved being treated with in the judgment. That it wasn't even dealt with, I'm afraid, proves its own point, which is that's an error. It should have been dealt with. It doesn't matter whether or not the point is last in line. My learned friends are obsessed by the hierarchy or the chronology of the points. That's just a bad point. The points that were taken before were done in a chronological way. That's as simple as that. And by the way, Mr Justice Calver did not find that there was a scattergun approach. On the contrary, Mr Bayard took Occam's razor to the points that he could have, and he ran the case on the basis of material non-disclosure, rather than any other point that came up. And the fact that you have more than one point that should be raised isn't an actual way of stopping a fair point being taken. So in the circumstance that Mr Justice Calver didn't say that this was to be criticised as an approach, I don't think that it really forced the Maloney Friends to raise the point now. And as to Maloney Friends Jr. being upset about the idea that a figure of time has been referred to, I just invite your lordships to look at paragraphs in due course, 52 to I think 54 or 55, and 88 to paragraph 90 of the skeleton argument, and just stop and have a look at the skeleton argument itself and see that there is no, it's very much left up in the air on what is otherwise a very thorough chronology. It looks to all intents and purposes as the amount of work, that's that huge skeleton argument, plus the 35-page affidavit, plus a 760-page exhibit that somebody put together. That is not the work of 2 or 3 days. It was a huge amount of work. I don't doubt that that is the case. But the point is, they don't disclose how long it took. They sit on their privileges in doing so. It's not unreasonable to conclude it took a long time. And that's only relevant to the point of what scant effort was made in respect to what we maintain were very serious material non-disclosures. Those are my submissions.
Thank you very much. You will not. Sorry, you want to say something?
I just wanted to clarify before I anticipate your lordship's surprise. I will send you, following our discussion, the Mr Justice Bryan order that gives the guillotine for the evidence, and a full and proper copy of the sworn affidavit of Mr Salceda, so that you can see that it was in fact sworn properly. And I think that those were the only two items.
And I think paragraph 7 of Sklarov 1.
I'm so sorry.
Understand
And Sklarov. Yes.
And if there's is there a transcript of this hearing going to be available?
Yes.
If we could be sent that.
Yes, of course.
The transcriber has been working hard in front of us. I can see it. And we're grateful for that labour. You will not be surprised to hear that we're not going to give you a decision here and now. We will reserve our judgments. Drafts will be circulated in the usual way in due course to counsel and solicitors whose details have been supplied. I'm sure you all know, but the purpose of that exercise is so as you can draw to our attention any typographical or minor factual errors, and also, secondly, in the hope that you'll be able to agree a draft order in the light of our decision. If you can't agree an order, please file brief written submissions, and we will determine the appropriate order in light of those written submissions. And finally, I'm sure you're all aware, but I should remind you that circulation to any other person for the purposes identified in the Counsel for General the Wales case is the responsibility of those instructing you, and must be for the purposes that I've described only, and any other publication may be in contempt of court. Thank you again.